Welcome to this video series on addressing the dispute resolution challenges of Japanese companies doing business in ASEAN. This video series is jointly produced by the ASEAN Japan Center, the Singapore International Arbitration Center, and the Singapore International Mediation Center. In this episode, we're exploring strategies to ensure effective and fair resolution of your cross-border disputes. I'm Michelle Sonin, and I am the head of Northeast Asia at SIAC. I am delighted to be here with three experienced international dispute resolution attorneys. Ms. Yoko Maeda of City-Yuwa Partners in Tokyo, Mr. Warathorn Wongsawangsiri of Herbert Freehills in Thailand, and Mr. Yu-Jin of Mayer Brown in Singapore. Japanese companies that do business in Southeast Asia are commonly concerned about how to manage their business risk, including disputes. What are some of the things that they should consider when engaged in trade or investment in ASEAN?
What we found is Japanese parties have been investing in Southeast Asia for a very long time, and therefore have a lot of experience in the region. And the region represents great opportunities for them. But one of the risks that tends to arise for Japanese parties is the fact that it's a diverse region with diverse histories, diverse legal systems and laws, diversity of languages and cultures, and still different states of economic development.
So what are the key elements that impact whether a dispute resolution process is fair and effective? Maybe you could tell us a little bit about that.
I think what the parties should be concerned about is whether the process is fundamentally neutral, and should be fair and reliable, and therefore something that would be attractive to both sides and easy to agree. International arbitration is increasingly popular and therefore familiar to many parties, both Southeast Asian parties and Japanese parties. And that has helped to ensure that an arbitration agreement is relatively easy to agree and incorporate within a contract. And when thinking about the arbitration agreement, naturally, you have to have a set of arbitration rules. And it's useful to apply a set of rules that is tried and tested, is considered to be the best in class, and again, is something that is quite popular and therefore familiar enough to both sides and hopefully their lawyers. And one of these sets of rules in the region is the Singapore International Arbitration Center's arbitration rules. And the SIAC's rules are currently the most popular in the region.
In addition to the arbitration institution that Yu-Jin just mentioned, I'd say that the choice of an arbitrator is also an important element for fair and effective arbitration procedure, because it is the arbitrator who will make decisions in procedural matters or substantive matters. So when appointing an arbitrator, a party considers many things like a candidate's capacity, knowledge in certain area, or experience in arbitration, governing law, language, or availability. But in particular for Japanese companies, I'd like to add that thinking about the legal culture, legal background of the arbitrator is also important, because in Japan, the contract tends to be relatively short and simple, and there are many items, issues that are left to the contract interpretation. But generally speaking, for example, common law lawyers are said to be more strict about the language of the contract and more reluctant to find rights obligation that is not explicitly provided in the contract language.
So in an international arbitration, once an award is issued in your favor, what happens next? How can I ensure that the non-prevailing party will comply with the award?
Well, fortunately, in my experience, in the majority of cases when an award is rendered, parties do comply with the awards. In the unfortunate instant where the losing party does not comply, then under the New York Convention, an arbitration award is enforceable in over some 160 plus countries, and therefore is the most portable legal outcome that we have in the world today. In Southeast Asia, as arbitration grows in its popularity, which is already the case, courts across Asia and their judges are becoming more familiar with and therefore less distrustful of arbitration as a process. And because of that, we can expect that the incidence of arbitration awards being successfully enforced in these countries can only increase.
I'm glad to say that among the cases that I have so far handled, there are only 2 cases that have ended up in enforcement procedure in a national court. And unfortunately, those cases are still pending in the court for a few years. But it is more important to note that in all the other cases, enforcement did not even become an issue because the losing party voluntarily performed its obligation after the arbitration award is rendered or a settlement was reached.
We just spoke about utilizing national courts to enforce an arbitral award. Looking at Thailand as an example, what do you advise parties seeking to enforce awards against Thai companies?
Yes, I would advise the winning party of arbitration to enforce the award in Thailand. Because Thailand is the party to New York Convention and we have Arbitration Act in Thailand. The step to be taken is quite not difficult, and it's different to initiate of the local new case. You just submit the petition to enforce award in Thailand within 3 years. From my experience, you will take just only 1 year to enforce the award for the court of first instance. Nowadays, the Thai court quite pro arbitration, and most of the case, 95% I would say, the court will enforce the award, even in against the Thai company or even against the Thai governmental entity.
Do you have any recent examples of awards that you've enforced for international companies in Thailand or against Thai companies?
Yes, we advise Chinese party to enforce the award, SIIC award in Thailand against the Thai company. It related to the JV company and they have like the put option in the JV company. And we won the arbitration in Singapore and we enforced the award for Thai party to try to buy the share back in the amount that's specified in award. And the court of first instance enforced the award for us, even though the Thai party tried to object it.
That's certainly going to be very comforting to some of our viewers who are concerned about the ability to enforce arbitral awards.
Yes, there are more and more international arbitration courts in Thailand. This is because from investor perspective, they don't want to go to Thai court for the lengthy long procedure in Thailand, and they're quite confident on the neutral arbitrator to render the award. Now, SIAC is more and more incoming for the dispute between the investor, Japanese investor, Chinese investor in Thailand against the Thai party. From my experience, the contract related to the party for foreign with Thai party with foreign party that would put international arbitration court in the agreement. Most of the time in international arbitration, before the hearing or before the tribunal render the award, both parties might have some discussion and talk and have used like mediation center to settle the dispute. The good thing, the advantage is that it's a win-win for the party. No need to spend a lot of money in the hearing for arbitration. That is the trend in Thailand that most parties want to like settle and go to international arbitration and also mediation center.
Stepping back slightly, can a less adversarial process like international mediation also help Japanese parties achieve a fair and effective result, particularly when used in conjunction with international arbitration?
There is a tendency or perception that Japanese companies prefer not to go to the court or engage in arbitration and rather opt for settlement. But at the same time, from my experience in advising both Japanese and foreign clients, I realized that Japanese clients are generally less eager to have settlement discussion than foreign clients once litigation or arbitration starts. So I'd like to advise Japanese companies to be aware that settlement or mediation is always a choice, even after the arbitration procedure has started. Because in many countries, filing an arbitration is just the first step to start settlement discussion seriously. And I would also like to advise Japanese companies that bringing in a mediator is very helpful to reach a settlement. Again, from my experience, Japanese companies are less eager to bring in mediator for settlement, and they rather try to engage in direct settlement negotiation with the other side. But in my experience, the success rate is much higher when a mediator is brought in.
To add to what Yoko has said, I think it's quite interesting because in Asia, the attitudes of lawyers and parties towards mediation is changing. And I think it's the same outside of Asia as well. It's a common stereotype of people to think that Japanese parties, among all the other Asian parties, are the most amenable to discussing settlement when a dispute arises. And to a large extent, that's not misconception because Japanese parties place a high degree of value in preserving relationships. One thing I am finding though, and this is not unique to the Japanese parties, is that parties and their lawyers in Asia are more willing to consider mediation both before and during an arbitration process. I think there are a few reasons for this change. One is the fact that there has been the signing of the Singapore Mediation Convention, which has resulted in a lot of training, a lot of buzz, a lot of proselytization of mediation. A lot of training of mediators in the region has also resulted in more lawyers becoming familiar with this and having such discussions with clients. People are beginning to understand that even a mediation that doesn't necessarily result in a settlement can be valuable to the dispute resolution process like arbitration, because it gives the parties and their lawyers a useful insight into what the other side might be thinking at a particular point in time. It might help to narrow issues. It leads to a more candid exchange of information during the arbitration. And even if they continue with the arbitration, they know why they're continuing with the arbitration and why they want to get to that binding result.
Thank you so much, Yoko, Yu-Jin, Warathorn. This has been extremely informative.